I was just suggesting that instead of reading the whole list of dates, since there are mostly statutory notifications and statutes, etc., I will indicate. I will read along with the. I'll go straight away to the document itself, so that we don't have to visit it twice. Now, broadly, let me just tell you the facts of my case in a nutshell. On 11th April, the applicant, the party I represent, Mr. Malvinder Singh, is a senior citizen. He's around 78 years of age now. Now, his son is based in the United States of America. And as is not uncommon, and it's a value which is greatly respected by this court, etc., and an aspect of dignity, familial bonds, etc., people visit their children overseas. There is care, there are connections which are restored, and that's how relationships are maintained. Your lordships have recognized over the years the right to travel abroad. So anyway, I exercised that right, not that anyone was stopping me, and I went abroad. I went abroad on 11th of April 2016. The announcement, as your lordship recalls, came on 8th of November 2016. Now, at that time when the announcement came, there was an assurance which was made by the Prime Minister, and it was followed by Reserve Bank of India assurance also, that look, 30th December 2016 is the deadline. But that will be extendable in the sense that at Reserve Bank of India designated branches, even after that deadline, you will be able to exchange your notes. Now, he had withdrawn and had in his custody, this is a little important for our facts, he had withdrawn and had a total of 1,62,000 rupees, which he had placed in his home in India. He's an Indian citizen when he went abroad. At that point of time, they were contemplating a knee surgery. Fortunately for us, or fortunately for him, there was alternative treatment, etc. And the surgery, for the knee surgery was not required, though there were certain other surgeries which were required as far as he's concerned. But he didn't have to go through with the knee surgery. He returned to India on the 3rd of February 2017. I'm just giving you a broad picture. So 3rd February 2017, he returns. Now, by this time, that ordinance has come into place. The moment he returns, he tries to exchange that 1,62,000, which is lying with him in the old currency notes. He writes letters, communications, those representations are there. The application comes to be rejected. Now he finds himself in a bind, and I'll just broadly indicate what the problem is. The problem is, first, he has come back after 31st December 2016. So that assurance which was extended by the Prime Minister and the Reserve Bank of India in the first instance has suddenly, according to the respondents, been overtaken or has been stands diminished or virtually eroded, let me say eroded, by a statute in the form of an ordinance, later on replaced as Act 2 of 2017. And what does that ordinance say? That ordinance in a nutshell says that, look, there is a hard stop. The hard stop is ordinance issued on 30th December of 2016. 24 hours later, 31st of December 2017, after that you cannot exchange notes. I'm just going very broadly. Of course, there are some narrow exceptions. So this is the first time where there is a hard stop introduced by way of a law with just a 24-hour window. Ordinance on 30th December, no exchange allowed after 31st of December. Then it says something interesting. It says that, look, if you are, now this is an exercise of powers under Section 4, etc. What they've said is that if you have left the country, just broadly indicate, if you have left the country, we have a law called FEMA, which your lordships are familiar with, Foreign Exchange Management Act. Now it allows you to carry currency outside India. FEMA allows you to export a certain quantity of Indian currency. When you are coming back into the country, FEMA also contemplates, if you are carrying such currency, to make a declaration. So what they have said is, under Section 4, that if you, up to that limit which FEMA recognizes, and on return to India, when you came back to India, if you made a customs declaration that, look, I am coming back to India with that declaration of those many notes under the limit, then we will exchange your notes. So what you will find in the law is that the effect is that people like me, who are Indians, who had kept their money in India,
I didn't take it abroad. There was no question of FEMA applying to me. I have my house and residence in India. I left my money over here in India. I came back, as I indicated, on the 3rd of February 2017, and I found that I was absolutely without any recourse. So this money had been rendered completely not, unless we are able to persuade your lordships otherwise. So the scheme, what I'm indicating is the scheme doesn't capture me or contemplate a situation of individuals like me at all who were abroad, who returned after the 31st of December 2016 and who had money in India, lawfully kept money in India. This is the broad background. This is the problem which I'm facing. And therefore, our respectful submission is, of course, we support all the submissions which were made yesterday, because naturally the consequence of striking down that action will be, there would be relief which would come to at least persons like me who've come before the court. That's one element. The second element is that even if we are able to eventually persuade your lordships with regard to the RBI, I will call them the RBI points, which means 26(2) and all those points, we hope to persuade your lordships that, look, there appears to at least us, or our understanding, to be a constitutional right under 300A. And when that is read with 21 and 14, situations like mine ought to be covered before you take away or extinguish someone's property. There has to be recourse. You can't take away my property. This is the most basic element, currency notes. So this is going to be by broad, respectful submission. If we can find a way out under section 4, nothing like it. This is the broad fact. Now, may I go to the list of dates? I'm sorry, a very long introduction.
The money is still with you?
Yes, the money is still with me. And when we go to the list of dates, I should just mention that there was a protective statement which was made by the Attorney General. It's not recorded in any of the court's orders which I have recorded, but there are contemporaneous news reports. Because the issue was that people who were in court and had that money, they were liable to prosecution, correct? Because under the Act, that was the scheme of the law. So a statement was made that no, we will not, as far as parties who are here before the court are concerned, we will not take such action. So for me, fortunately, that hasn't happened. I have no complaint on that score. But that's just to complete the picture. So this is the background. Now, may I request your lordships have the list of dates?
So we begin on 3rd December 2015. Mr. Malvinder Singh, a senior citizen and an NRI, withdrew an amount of rupees 1,20,000 from his bank account in the Central Cooperative Bank, Sangrur, Punjab, branch so-and-so, and kept the amount along with earlier savings of rupees 42,000 in cash. The amount was saved in anticipation of a knee operation. Thus, a total of rupees 1,62,000. The entire cash is held in 500 and 1,000 rupee bank notes. We have given you the details of how it adds up. 132 notes of 1,000, 60 notes of rupees 500. We've given you the breakup. March 2016. By March 2016, the currency notes in denominations of rupees 500 and rupees 1,000 constituted 47.8% and 38.6% of the currency in circulation. In aggregate, this is 86.4% of the total currency in circulation. So this is a little earlier, March 2016. Now, my lord, since your lordships have volume 1, may I just indicate, how this list of dates of mine works. So just please go to page 1 of compilation volume 2, just for a moment, so that we know how the referencing is done. So you will have, this is the Reserve Bank of India report itself. It's called the annual report for 27-2018. It begins at page 1. Your lordships have that on volume 2. And please go to page 2. On the right-hand column, you will find table 8.1. Your lordships have table 8.1. My lords, compilation volume 2.
Oh, sorry. It's called compilation of documents on behalf of the applicant on the economic and financial issues.
The economic and...
Sorry.
That is volume 2.
No.
I'm going to request you to please mark Roman 2 on it, because my list of dates mentions Roman 2.
Yes. Right.
You are referring to annual report.
Yes, annual.
Annual report 2017-2018.
Absolutely right.
There is no volume number, etc.
Yes, so may I just, sorry, that's my mistake. I had it on my copy, so when the list of dates was prepared, it was marked as.
Assisting, I mean, lawyers are more considerate towards you and not towards.
No,
So now we'll call this volume one,
accepted.
the other one volume two.
Yeah, may I just request that this may be just marked 2. Thank you very much.
So page 1 is the annual report of Reserve Bank of India. So just one thing which you have to see on page 2, there's a table 8.1, banknotes in circulation. Your lordships have that. And as against March 2016, you will find two figures, my lords, against 500, you will find 47.8 in brackets.
And against under 1000, you will find in brackets 38.6. So when you add up both 47.8 plus 38.6, you arrive at 86.4. So that's where the figure of 86.4% being the amount of currency in circulation figure which we get. Then returning to my list of dates.
No, that is the value in billion.
Yes, that's the percentage, my lords.
That is not a volume.
The percentage of the value in rupees billion.
It is in
Just see the note. Figures in parentheses represent the percentage share in total volume value. Your lordship has that? So therefore, we have added 47.8% and 38.6%, and therefore the percentage in value comes to 86.4% of the total currency in circulation. Enormous. Now returning to my list of dates. 11th April 2016, Mr. Singh and his wife travelled to the United States to meet their son, who is residing there. The savings of rupees 1,62,000 were kept in their home in Sangrur during this visit to the United States. Now, I won't take you to these, but we have given you the passport pages which give you the exit date, etc. But I won't be meaning to take you to that. Now, my lords, 8th of November. So, lots of things happened on 8th of November 2016. May I take you to the compilation so that your lordships will not have to read the list of dates. So, please go now. We are on volume 1 of the compilation. And please just have a look. Go straight away. Your lordships may go to page 24.
This is going to be a very important plank for my submission. Well, this is the Prime Minister of India making a very, very important policy announcement. It contains certain assurances and representations. In my respectful submission, any measure of reasonable conduct, this ought to provide a suitable base benchmark. It is not for the government to say and the respondents to now say that no, we will ignore what was stated in this particular address to the nation. So I am using it at 2. I mean, technically they may be right. Obviously, there's no estoppel against some legislature and all that. Nobody is suggesting that. But I am saying as a benchmark of reasonableness, as a benchmark of fairness, because I think the Prime Minister's speech is reasonable and fair with regard to this issue of exchange of notes is concerned. And now to depart from it and to deprive someone like me, according to me, if we are right, is probably improper on the part of the respondents. So the speech itself begins on 8 November 2016 at page 24. Your lordship may go straight away to the foot of page 26. There is an enumeration there. The steps will strengthen the hands of the common man in the fight against corruption, black money, and fake currency. Sorry, it begins at page 24.
Yes.
Compilation 1. Okay. Your lordship has page 26. So, now I'm taking advantage of improper advantage of Justice Gawai's question and
Reading from one paragraph earlier. So, just brothers and sisters, about 10 lines from the bottom, your lordship sir. Brothers and sisters, to break the grip of corruption and black money, we have decided that 500 rupees and 1000 rupee currency notes presently in use will no longer be legal tender from midnight to night. That is the 8th of November 2016. This means that these notes will not be acceptable for transactions from midnight onwards. The 500 and 1000 rupee notes hoarded by anti-national and anti-social elements will become just worthless pieces of paper. The right and interests of honest, hardworking people will be fully protected. let me assure you that the notes of 100, 50, 20, 10, 5, 2 and 1 rupee and all coins will remain legal tender and will not be affected. This step will strengthen the hands of the common man in the fight against corruption, black money and fake currency. To minimize the difficulties of citizens in the coming days, several steps are being taken. One, persons holding old notes of 500 and 1000 rupees can deposit these notes in their bank or post office accounts from the 10th of November till close of banking hours on 30th November 2016 without any limit. Thus, you will have 50 days to deposit the notes and there is no need for panic. Now, let's see number 3, please. Your money will remain yours. You need have no worry on this point. This is very, very important, Bharat. Very, very important and very fair and very correct. Please go to paragraph 9. Several assurances extended. Para 9. There may be some who, for some reason, are not able to deposit their old 500 and 1000 rupee notes by 30th December 2016. Then, they can go to specified offices of the Reserve Bank of India up to 31st March 2017 and deposit the notes after submitting a declaration form. Now, this is a very solemn, fair declaration. So, at least I of course, arrived well before, I arrived in February. So, well before 31st March 2017. This is now the assurance which is held out across to the people of India. And I believe it is entitled to the highest degree of respect. Then please go, yes, so I'm done with these points 9 and 10. Since we are on the compilation, please go to page 31.
At 33. So this is again on the same date, 8th November 2016. Your Lordships have a statutory notification.
Yes.
This was referred to by Mr. Chidambaram from another compilation itself. So here, my lords, I'm just emphasizing 2 or 3 points. I'll just read the recitals and then one clause. Whereas the Central Board of Directors of the Reserve Bank, hereinafter referred to as the board, has recommended that bank notes of denominations of the existing series of value of 500 rupees and 1000 rupees, hereinafter referred to as specified bank notes, shall be ceased to be legal tender. And then they talk about the problem of fake currency. The next recital talks about high denomination banknotes used for storage of unaccounted wealth. Further recital makes a reference to subversive activities such as drug trafficking and terrorism, causing damage to the economy and security of the country. Now, therefore, in exercise of section 26(2), to the extent specified below, namely, the central government hereby declares that the specified banknotes shall cease to be legal tender with effect from 9th of November to the extent specified below, namely. Now, in these various conditions, please go to clause 9. For my purposes, page 34. Any person who is unable to exchange or deposit the specified bank notes in the bank accounts on or before the 30th of December 2016 shall be given an opportunity to do at specified offices of Reserve Bank of India or such other facility until a later date as may be specified by it. So again, this is now a statutory notification under 26(2). Your Lordship sees at this point of time, I'm in the United States. And all right, I have plans, etc. to return. This is completely consistent. I would say that this is completely consistent with the assurance which was extended by the Prime Minister in his address to the nation. So there's no problem with this either. So at specified banks or branches of offices of Reserve Bank of India, even after 30th of December 2016, there ought not to be any problem on this issue. Yes. Now please go to page 35. Page 35. Now this is again same date, 8th of November 2016. And this is the Press Information Bureau. Here again, there are just 2 clauses that I want to highlight. After mentioning, my lords, the ills which are sought to be addressed, counterfeit note, your lordship, the subversive activities, espionage, smuggling of arms, drugs, contrabands into India, etc., eliminating black money. Now, please see paragraph 4. In the last 2 years, the government has taken a number of steps to curb the menace of black money
in the economy, including setting up of special investigation team, enacting a law regarding undisclosed foreign income and assets, amending the double taxation avoidance agreement between India and Mauritius and India and Cyprus, reaching the understanding with Switzerland for getting information of bank accounts held by Indians with HSBC, encouraging the use of non-cash and digital payments, amending the Benami Transaction Act, and implementing the income declaration scheme of 2016. And now please go overleaf to clause 10.
In para 5 opening words at page 35, they say the following operational guidelines have been issued. Operational guideline number 10 at page 36 reads, for those who are unable to exchange the old high denomination banknotes or deposit the same in their bank accounts on or before December 30th, 2016, an opportunity will be given to them.
Will be given to them to do so at specified offices of the Reserve Bank of India on later dates, along with necessary documentation as may be specified by the Reserve Bank of India. So it's broadly unconditional. Of course, you have to proceed certain documents, etc. But broadly, at least the representation made at this point of time is also based on is sort of that you can, that 30th December 2016 or 31st December is not going to be a hard stop. Now please go to yet another Reserve Bank of India press release at page 37. Page 37. Same date, 8 November 2016. Page 37.
And here I invite attention to the second last paragraph on that page. Any person who is unable to exchange or deposit the specified banknotes in their bank accounts on or before December 30th, 2016 shall be given an opportunity to do so at specified offices of the Reserve Bank or such other facility until a later date as may be specified by the Reserve Bank. So everyone is speaking in one voice, and I think this is a very, very reasonable representation made. Prime Minister, Government Bureau, Finance Ministry notification, Press Bureau, Reserve Bank of India press release. So and therefore, because I don't think that response to the short affidavit, which I just referred to, where they said, no, we are not going to consider this under section 4 of the ordinance, doesn't appear, at least according to us, to be justified. Now, Your Lordship need not turn to the list of dates, but I'll just read the item. I'll just read the items, or you may follow it, the list of dates. I'm not going to read very much till the next statutory document. Foot of page 3, November 16, several writ petitions were filed challenging the policy of demonetization before various high courts and the Supreme Court. Transfer petitions were filed by the Union, seeking transfer of all the matters pending before the high courts to the Supreme Court. Then the 16th December 2016 order bench presided over by Justice Thakur, I've already read, so I'm going to skip that item. Then please go to 30th December 2016. Now this becomes important because this was not placed in the sense it may have been referred to yesterday, but it wasn't as such placed. So this becomes very important development on 30th December 2016. Let us go to page 38 of the compilation volume 1. Now let me just state the point here. Our focus yesterday was on section 26 when Mr. Chidambaram was arguing it. May I, with your permission, just take you for a moment to section 34 of the RBI Act. Just for a moment, let us just take up section 34. I'll come back to this, but Your Lordship may just cite it for a moment. Here. Your Lordships have it? 34. So this is the focus now. Please see liabilities of the issue department. Your Lordship went through the scheme of the issue department, etc. Now look at 34. The liabilities of the issue department shall be an amount equal to the total of the amount of currency notes of the Government of India and bank notes for the time being in circulation. So this is an independent liability created under statute under 34. So two obligations. Apart from their sole power to issue notes, etc., look at 26(1). Subject to the provisions of subsection 2, every banknote shall be legal tender
at the place in India in payment or on account of the amount expressed therein and shall be guaranteed by the central government. So guarantee of the central government is one legal concept. Liability of the Reserve Bank of India issue department is a second legal concept.
We come to it. But the reason I'm flagging it is that this ordinance seeks to.
I didn't get it.
Sorry.
I didn't get your submission.
Yes. Sorry, Manoj. I'm just pointing out very briefly at this point because I'm going to take you to the ordinance. And just in anticipation of what does the ordinance do, I'm just explaining what it does. What it does is it extinguishes two statutory obligations. So conceptually under the Reserve Bank of India Act, we saw that yesterday, there is an exclusive authority or power to issue notes that your Lordship saw yesterday. Only the Reserve Bank of India. That's for global concerns. You are managing this type of an economy, huge economy, complexities, etc. People to have confidence in the system, you create a separate Reserve Bank and you confer that authority on the Reserve Bank of India. So that's one aspect. Now, how does that particular currency note which is in circulation, how does it have, how is it honored? And how does it gain, in a manner of speaking, currency or confidence in the public? The confidence comes to the public as a medium of exchange. So store of value is one element. Medium of exchange. That comes from what? It comes from two legal obligations which the Act itself imposes. One on the Government of India and the other on the Reserve Bank of India. Now what are those? 26(1) is guaranteed by the central government. Your Lordship has seen that. So that, Justice Gawai.
Yes.
Guaranteed by the central government. So, I mean, the entire sovereignty, integrity of the nation backs this particular note which is issued in terms of this Act. That's one, the central government, highest authority in our country. Then there is a further independent obligation because, I mean, private banks or, I mean, by private banks, I mean non-Reserve Bank of India, whether it's nationalized or otherwise, have in the old days, your Lordship recall, they used to issue their currency notes as well. But now that is all abolished and there's an embargo on that. Then whose liability will it be? So the liabilities of the issuance department of the Reserve Bank, please see section 34. So guarantee, but who has to pay? The payment in the first instance is in terms by the issuance department. Liabilities of the issue department shall be an amount equal to the total amount of currency notes of the Government of India and bank notes for the time being in circulation. This is sought to be now extinguished, as we will see from the ordinance. So that was just the background. Now let us see what the ordinance does. So first, if you now compilation 1, page 38. So please see, this is titled the Specified Bank Notes Cessation of Liabilities Ordinance 2016. Please note the date 30th December 2016. Your Lordships have that? 30th December 2016, this is issued. And when we go further down, you will find it comes into force straight away on the appointed date is 31st December 16. I'll come to that. Now let us see, my lords, the recitals. An ordinance to provide for the cessation of liabilities on the specified bank notes and for matters connected therewith and incidental thereto. Whereas the central government, on the recommendations of the central board with a notification of 8 November, declared that the then existing series of bank notes of the denominational value of 500 rupees and 1000 rupees ceased to be legal tender from 9th November 16. Whereas a part of the series of bank notes in circulation which have ceased to be legal tender on account of the said notification has come back to the Reserve Bank of India. Whereas such bank notes which have ceased to be legal tender are a liability on the books of account. I think it should be account, it can't be accounts. In the books of account of the Reserve Bank of India under section 34 of the Reserve Bank of India Act 1934. And whereas it is necessary to have clarity and finality to the liabilities of the Reserve Bank of India and the central government arising from such bank notes which have ceased to be legal tender on the basis of the said notifications, and whereas Parliament is not in session and the President is satisfied that the circumstances exist which render it necessary for him to take immediate action. Now therefore in exercise Article 123, the ordinance, it shall come into force on 31st day of December 2016. In the said ordinance, unless the context otherwise requires, Appointed date is 31st December 2016. Then you have a statutory definition of grace period, means the period to be specified by the central government by notification, during which the specified bank notes can be deposited in accordance with the ordinance. Notification means the notification published in the official gazette. Reserve Bank specified banknote are the 500 and 1000 rupee notes of the series existing on or before 8th of November 2016. Now please see section 3. So section 3 is important for our purposes. The marginal note, specified bank notes to cease to be liability of the Reserve Bank or central government. On and from the appointed date, notwithstanding anything contained in the RBI Act or any other law for the time being in force, the specified bank notes which have ceased to be legal tender in view of the notification of the Government of India dated 8 November 2016 issued under section 26(2) of the RBI Act shall cease to be liabilities of the Reserve Bank under section 34 and shall cease to have the guarantee of the central government under subsection 1 of section 26 of the Act. So this is the statutory. Now look at section 4, which we will focus on, but I'll read through it. Exchange of specified banknotes. Section 4.1. Notwithstanding anything contained in 3. So it's a non-obstant clause. It overrides 3. Of the following persons holding specified banknotes on or before the 8th day of November 2016 shall be entitled to tender within the grace period with such declarations or statements at such offices of the Reserve Bank or in such manner as may be specified by it, namely, 1. A citizen of India who makes a declaration that he was outside India between 9th November 16 and 30th December 16, subject to the conditions as may be specified by the notification by the central government, or 2. Such class of persons and for such reasons as may be specified by notification by the central government. So there is a power. We'll come to that. But there seems to be a power for grace period. Now look at subsection 2. The Reserve Bank may, if satisfied, after making such verifications as it may consider necessary, that the reasons for failure to deposit the notes within the period specified in the notification referred to in section 3 are genuine, credit the value of the notes in his Know Your Customer compliant bank account in such manner as may be specified by it. So there's an overarching power under 4. There's a power as we read it under 4.1 as well as 4.2, at least on our reading of it. And 4.3, any person aggrieved by the refusal of the Reserve Bank to credit the value of the notes in subsection 2 may make a representation to the Central Board of the Reserve Bank within 14 days of communication of such refusal to him. An explanation, your Lordship may just know mine is a Know Your Customer compliant bank account. For the purpose of this section, the expression Know Your Customer compliant bank account means an account which complies with the conditions specified in the regulations made by the Reserve Bank under the Banking Regulations Act 49. Then section 5 is prohibition on holding, transferring or receiving specified banknotes. Penalty for contravention of section 4 is section 6. Penalty for contravention of section 5 is section 7. Offences by companies. Special provisions relating to offences is section 9. 10. Protection of actions taken in good faith, power to make rules, power to remove difficulties. And just for completeness on this aspect, you may note, I will stick to my list of dates, stick to the sequence, but just for cross-reference, you may note that the Act in the same terms is at page 53 of this paper book. It is Act number 2 of 2017. So that's now the provisions which are actually extant and which are in force. So this is what replaced the ordinance. It begins at page 53. It runs all the way up to page 56.
Now, sorry. Now, may I go back to the
No
comment?
change, there is no change.
There's no change. There's no change.
You
It's
might
in-
refer to the act in your list of dates.
Yes, I have referred to the Act. It will come. Sorry, I should indicate where that comes. Bottom of page 7.
Yes.
Your Lordships have an item 27th February 2017. May I continue? Yes. So please go now to the an event which occurred on the same day, page 44 of the compilation. This is 30th December 2016. In exercise of powers conferred by clause B of subsection 1 of section 2, read with clause 1 of subsection 1 of section 4 of the ordinance, the central government hereby specifies, in respect of citizens of India referred to in clause 1 of subsection 1 of section 4 of the said ordinance, A, who is a resident in India, the period ending on 31st day of March 2017. So this is the grace period. This will not affect me because it is for a person who's resident in India. So this will not, I'm just mentioning it in the facts of my case. Then B, who is not resident in India, the period ending with 30th June 2017. So I may be covered by this, but we will see as to how it operates as the grace period for the purposes of the said ordinance. Correct?
Resident or non-resident as on what date?
That's period ending is given. Oh, I'm sorry. Grace period. I'll just examine that and come back to your lordships on this. No, the act says so.
Does the act or ordinance?
The ordinances.
As on.
Absolutely right.
Suppose they have gone out just the previous day for a 6 months tour.
Correct. We'll just examine that and come
First
back.
week of November if they have gone.
As on what date? NRI, I don't know. I recall reading it, but I'll try and just come back. Now let's please see the proviso. That's of relevance. The proviso at page 44. This is right at the end of the grace period for the purpose of the said ordinance. Provided that the amount of specified banknotes tendered does not exceed the amount specified under Regulation 3 or Regulation 8 of the FEMA Export and Import of Currency Regulations 2015, made under the provisions of FEMA and the conditions specified therein are complied with. Can I just explain the effect of it? What this says is that provided the amount of the specified notes does not exceed the amount, what they are doing therefore by this proviso is they are extending the grace period only to people who had taken money out and brought money back in and made that declaration. That will become clear from the next notifications, etc., which I read. I hope I've made. So there is a grace period which is extended. The grace period is 31st March 2017 for those resident in India. And if you are not resident in India, it is a period ending on 30th of June 2017. Correct? But what's the proviso? The proviso says that this FEMA requirement cannot be exceeded. So 2 or 3 problems. So this will apply only
Yes, it will be applicable to all persons who are outside India between 9th November 2016 to 30th of December 2016.
yes.
Yes, and the grace period distinguishes insofar as Indian residents are concerned, it will be up to 31st of March 2017. And insofar as NRIs are concerned, it will be up to 30th of June 2017.
Absolutely right. Now see the proviso. I think there's no, I think on that aspect, I would agree with what, see the proviso. Provided, I'm on page 44.
Yes,
Provided that the amount, so there's a cap. The amount of specified banknotes tendered does not exceed the amount specified under Regulation 3 or Regulation 8 of the FEMA export regulations dated made under the provisions of FEMA and conditions specified therein are complied with. So there is a cap. And what is this cap in respect of? I asked myself. This cap is in respect of what you could export out of India and what you could bring back in India. So I mentioned there are two situations. There are situations where someone like me, which is my case, has left the currency in India.
So according to what is given to you by the substantive provision, is being taken by where provider.
Well, could have been given to me. You're right. Absolutely right. The conditions imposed by the proviso, because of the proviso, exclude operation of this notification to a person like me entirely. Entirely. An Indian who has gone out and who had left his money in India, whether he be an NRI or a resident of India, but returned after 31st of December 2016, is completely out. Completely out. The question I ask myself is, and we'll see that the grace period is then given in the next document. So,
4.1, 4 section.
yes, 4.
Because 4.1 relates to only persons who have gone out of India.
Yes,
But this clause A in the notification,
yes,
it speaks of a person who is resident in India.
yes.
A person who is resident in India, that cannot be related to 4.1 at all.
Because that is a person who has gone out.
No, so sorry. So resident dwellers, as I
You have to
understand it,
understand what is the meaning of because resident and who is, if he is resident in India,
yes.
he is not a person who has gone outside in India.
So sorry.
Between
So,
the two periods.
so I'll just I'll from the income tax.
Now, even for a resident in India, this proviso applies. Even if he has not gone out.
Yes. So sorry.
Means he was in India, or does it mean resident, non-resident as
Yes,
per
it means
income tax?
resident and non-resident.
As per
NRI, you have a notion. You
as
have
per
an
Income Tax Act.
under the Income Tax Act. So I think my preliminary response would be resident or NRI in that financial year, because we are going on the basis of a financial year. So there is that benchmark of 182 days, etc., which applies to determine whether you are resident in India or whether you are a non-resident Indian. So the way I would reckon, so I'm sorry, I'm repeating myself. The way I see it, the way I see this operating, now I'm on the notification, is that yes, it does define a grace period. However, the proviso operates in such a manner which is not fully fleshed out from reading this notification. I have to read one further document and it will become clear. The proviso takes people like me who had left money in India completely out of the purview of any benefit of grace period. And that is how it is operating, and that is how they understand it to operate, and therefore my application has been rejected. Even though I had withdrawn money from the bank, I had kept it in India, I can explain the entire amount. But I came back in February, that's all. There is no grace period for me at all on its working. Now it may become a little clearer from the next document, page 45. Just let us see page 45, same. See now what the RBI says, and I think it will become clear from here what they mean by resident, non-resident, etc. Your Lordships have the circular, which is issued by the RBI on 31st December 2016. So this is again during the ordinance. Facility for exchange of specified bank notes during the grace period, verification of KYC account details, etc. Please refer to the Government of India. This is notes to all the chairmen of various banks, cooperative banks, etc. Please refer to the Government of India ordinance dated 30th December 2016 on the specified bank note cessation of liabilities. In terms of para 4.1, the above facility
The exchange of specified bank notes is made available for resident and non-resident citizens who could not avail the facility from November 10th to 30th December 2016 on account of their absence from India during this period. In particular, the above facility is available only to those tenderers whose accounts are KYC compliant and who have not deposited SBNs into the amounts from 30th November to December 30th. As the above information is available with banks, specific offices of RBI will be approaching the banks for number 1, confirming KYC status, and 2, information on deposits of SBNs, if any, into the accounts of the tenderers. The banks are therefore advised to put in place an arrangement to furnish the required information within 7 days from the date of receipt of this request. Towards this, the banks may designate an officer at the rank of the general manager as a nodal officer and may be conducted by the office. The name, contacts, etc. Please acknowledge receipt. Now see the next page. Page 46. Facility for exchange of SBNs during grace period. In terms of 4.1 of the Ordinance 2016 and notification of December 30th, 2016 thereunder, the captioned facility has been formulated by the Reserve Bank of India to afford an opportunity to those Indian citizens who could not avail the facility of exchange of SBNs under the earlier facility, and they are not present in the country during the period November 9th to 30th December 2016. Places of exchange, eligible persons are given, are indicated, etc. Now please see resident Indians. So only those, I'm on top of page 47, only those residents who were abroad during the period November 6th to 30th December 2016 will be eligible to avail the facility only once during the tenure of the facility. There will be no monetary limit for submission of SBNs in the tender. So this is important because it's a measure of reasonableness. They realize that if you are qualifying, etc., no monetary limit for submission of SBNs in the tender. Then these are, of course, residents in India. Tenderers should be submitted in tender form as per Annexure 1. A copy of the passport with the immigration stamp, etc., should be given. Now, please see B, NRI. This covers me. This covers me because I was non-resident given the number of days I had spent. Only those NRIs who are not present in India during the period November 9th to December 30th will be eligible to avail this facility once during the tenure of the facility. Tenders should be submitted along with tender form 2. Now see this. Tenders will be restricted to a maximum of 25,000 rupees per individual, depending on when notes were taken out of India as per the relevant FEMA rules. A copy of the passport with immigration stamp as proof of the individual's absence from the country during the period. Passport in original should be presented at the RBI counter for verification. Now please see next item 5. A certificate issued by Indian Customs on arrival through Red Channel after December 30th, 2016, indicating the import of SBNs with details and value thereof should also be submitted. Copies of statement of all bank accounts evidencing that no SBNs were deposited during so-and-so period. Requisite documents as per the provisions of 114B of the income tax rules. An acknowledgement of receipt will be issued to the tenderers pending credit of the admissible amount. 9. On ascertaining that the tenderer was abroad during the period from November 9 to December 30th, the account is KYC compliant, fulfillment of other conditions, and genuineness of the notes tendered, admissible amount will be credited to the amount under the advice of the tenderer. And then the duration is given. The facility will remain open from 2nd January to 31st March, and for NRIs up till 30th June. Representation, any person, etc., aggrieved, etc., may be the same. Then the tender form is Annexure 1, which is at page 49. Yes.
One question, please.
Yes, of course.
Are you a NRI or a resident Indian who has gone abroad? You belong to which category?
All right. So I just tell you, Lord,
Are you a NRI?
So first I'll answer the question. Am a NRI?
You are NRI.
Yes. Now the concept of NRI is dependent upon the number of days you are in India, or conversely the number of days which you are outside India within that particular financial year. So just to answer the question, I'm a citizen of India. That's my first characteristic. The second characteristic is That's the question being put to me. Am I an NRI or a resident Indian for the purposes of our case?
Yes.
I am an NRI for the purposes of our case for that financial year. However, I should just indicate to you, as your lordships already know, my status as NRI is dependent on how many days I'm outside the country or within the country. So that may change from year to year.
Had you been then there would have been no difficulty. So then,
May not have been. I hope not. I don't know.
because then if you read
At least the top of page 47.
47 clause A,
Right.
there is no requirement with regard to 25,000 and certification of SEMA.
Yes.
And then the only thing is that the grace period would have been available to you only till March end.
Correct. So then, well, first of all, I agree with the observation made by the court.
However, I want to just take you back 2 pages to page 44. The question will therefore be that proviso applies only to B. I mean, that's how.
If you read 40, 45, 46, 47,
That's right.
it will apply only to me.
That's right. Yeah, correct. So, I mean,
It also appears to be their interpretation.
yeah, at the moment, I don't know what will come out over here, but it's possible. So, therefore, what am I being punctured or what am I being hit by? As your lordship correctly puts it, first I'm being hit by the fact that I'm a non-resident Indian. That's the first aspect which I'm being hit by. The consequence of that is twofold. First, there's a cap that your lordships have seen.
25,000.
Correct. And second, there is all this compliance with requirements to making a declaration in the Red Channel, etc. When I came back to India. So it's something which I should have exported and brought back to India. That's the second requirement of just having even 25,000 I can't exchange. So for an NRI, it is very constricted because it is not just an NRI with a cap of 25. It's NRI. I took the money abroad with me and I brought it back. So in other words, another way of looking at it, it doesn't cover a situation like mine where I'm an NRI who has lawfully left money in India at my residence.
So this notification doesn't apply to you.
The notification does because otherwise, unless the notification
Because
applies.
the money is in India. You have not taken it out and brought it back.
All right. Then my problem is there's no grace period. That's going to be my argument.
Yes. Therefore, if it is construed that this notification applies to only those persons who at that particular period gone out and probably they have taken some Indian currency out and they are bringing it to those persons who had gone out but kept the money in India. Which notification applies?
Nothing.
Where is the grace
Right.
period for them?
So this is absolutely correct.
Yes.
Manoj, I'm just answering this question. So the submission is going to be this. The submission is that Article 14, I mean, let's keep 21 and 300A aside. 14 what's happened here? Prime Minister's statement, Reserve Bank of India statement is you will have an exemption or you will have some opportunity at Reserve Bank of India branches even after 30th of December 2016. That was the general understanding, etc.
Suddenly we have an ordinance on 30th December which gives a hard stop on 31st of December 2016. Nothing after that unless you qualify for grace period. So one limb of my argument will be that this is arbitrary. I'm just on a 14 issue, we'll see 300A, etc. of suddenly bringing a closure and having no opportunity for someone like me at all. Money kept over here in India. So it falls foul, according to us, it suffers from a vice in terms of Article 14. That's one. And the second limb of the argument will be, a softer limb will be, that look, you have the power under Section 4 Please cover me with a grace period direction and a notification for someone like me, who's an Indian citizen, who earned this money lawfully, who retained and kept it in India. Surely I just happened to arrive after 31st December. I arrived in February 2017. Surely you should exercise your power. It's coupled with the duty to exercise your power to cover me under the notification. So that's the softer approach in terms of we don't need to strike down anything. But it's something which they have a duty and a responsibility. They have the power for sure under 4. They must exercise that power. So this is broadly, your lordships are correct. This is exactly where I am. Either under section 4 you cover me, I mean, then I'm happy. If not, if they're still refusing to, because nothing, they've said on affidavit, no, we're not going to do it, come whatever. We are not obliged to do it, despite all these representations which are made. Then I am seeking the intervention of the court. And if your lordship feels that no, these are matters, etc., which are of high fiscal policy, 1,62,000 of an Indian, what's to the government of India and the larger picture, then I'm going to request your lordship to strike it down. Because then you are taking away my 300A right, valuable property. I'm not a black marketeer. I'm not engaging in some terrorist activity. Nobody claims that I have fake currency notes. So, the object which you are seeking to achieve, because you have an object, that's the article, that the classical Article 14 test is there must be a rational nexus to what you are seeking to achieve. How does excluding people in my category, and you can imagine how many there must be of this type. It's very few who've come here before this court and who are petitioning the court. I am, of course, only for myself. Let me make that clear. But how many must be there who came back after 31st of December and found that they had some notes which were lying with them, hadn't carried them out, and they're completely excluded. Anyway, that's something which your lordship will keep in mind. Now, may I just quickly return? So then there is at page 53 of that same compilation, the Act, which is in the same terms, but that's really what we need to consider. And after that, my lords, I might just indicate what we have given.
So now, Manoj, I'm just completing this volume 1. But actually, I have to. So just let us take up the list of dates. Most of the statutory documents, etc., are already read and placed before this court. So you may go straight away to the top of page 7, where on 3rd of February 2017, the applicant returned to India. Your lordships have that. I returned to India on 3rd February 2017. I'm on my list of dates.
And again, we've given those passport stamps, etc. Then shortly after arriving,
Yes, sir.
You kindly also refer to subsection 2 at page 40.
And the 3. And the 3 also.
At 3 also.
Page 40, yes. That's the other power. Very much. May I read it?
The Reserve Bank of India.
Oh, yes. Now look at this. This is a very wide independent power. The Reserve Bank may, if satisfied, after making such verifications as it may consider necessary,
that the reasons for failure to deposit the notes within the period specified in the notification referred to in section 3 are genuine, credit the value of the notes in his know your customer compliant bank account in such manner as may be specified by it. Absolutely right.
And then subsection 3.
Yes, any person aggrieved, etc., may go to the Reserve Bank. So what happened here, I should just indicate. It will come in my list of dates. I made a representation to the Reserve Bank of India. The Reserve Bank of India rejected the representation. Then after representations were made, etc., they said also that the matter is sub judice, etc. So now for whatever reason.
So is it for the reason that it is contrary to the proviso at page?
Yes, that's how I read it.
Page
They said that we are not qualified.
No, what is the reason given by them for rejecting your expression?
And also, no, because he came.
It's an oral rejection. It will come in my list of dates.
No, because in an individual case like yours, if the Reserve Bank, though your case is genuine, does not consider a case,
Yeah.
the board also refuses a representation.
Yeah.
Individual directions could be issued under Article 226 or even under 32 by the
Of course, it must.
without going to the other question.
Yes, I believe so. I do. That's exactly my point. My point is that under section, that's that power coupled with duty. You have a duty to exercise this.
Then the notification would not apply to you.
Right.
And if the power exercised by the RBI
Yeah.
under 2
Yeah.
or by the board
Yeah.
under 3
Right.
is not exercised in a reasonable manner, not taking into consideration relevant factors.
Right.
In individual cases, we can hold that the RBI is bound
Of course,
to
yeah.
exercise this power.
Absolutely, and I'm going to therefore show your lordship how can there be this kind of resistance and saying that you're either covered by the circular or not. That when your lordships will hear them, you will see as to why. There's a reason for that. Why they're taking such a hard.
Because notification is distributed only under 4.1.
That's how I would read it, but I will. So I'm just formulating it from my perspective. I'm in 100% agreement with the formulation from the court or the tentative observation from the court in terms of section 4.
Always subject to hearing then.
Of course, subject to hearing it. So my submission, since your lordship has already captured the point, my submission is both power coupled with duty is both under 4.1 and under 4.2. I must get relief. I mean, that's if we are able to persuade it. And that's it there. So I agree with what the observation made. Because here, I'll just mention it. Of course, while it's an individual case, what Justice Nagaratna mentioned just a short while ago was that, can you imagine how many such people there are? There are people who go out of the country, they've left their, the example which was given is, there's a grandchild which is born overseas, somewhere, because you have these technical techies, I think, I hope I'm permitted to use that expression. I don't know whether it's parliamentary, but anyway, persons of great technical skill who go abroad. A child is born, the grandparents, because of care, etc., affection, seeing the child, they go there. They've left all their money over here. And they come back after 31st of December.
notification to the.
Now, what is the recourse as far as they are concerned?
They could be covered under 4.2,
I believe so. I believe they could be covered under 4.2,
but a notification must be issued.
No, it's an individual case.
specified in the notification.
Genuine-
It could be over it. I'll just read it for two. The Reserve Bank, if satisfied after making such verifications as it considers necessary, that the reasons for failure to deposit the amounts within the specified period in the notification referred to in 3 are genuine, credit the bank.
No, that is only a notification under 4.1, small Roman 1. There could be other class of persons as per 4.1.
Yes, you are right.
2.
Correct. That is also so. That is correct also. So actually there should be a notification by the central government to cover such situations. Anyway, I'll just flag for a moment. You will find situations.
There could be a myriad situations like this. I don't want to be, and apart from people traveling abroad, which is of course my case, there may be people who are hospitalized, etc. There may be people who are temporarily, for whatever reason, infirm, cannot make it. There has to be some facility according to us. So just to complete now this volume, I'm not going to, of course, take you to the.
By prima facie, it appears that subsection 2 and subsection 3 are there to take care of such eventuality.
It could
Because
be.
it doesn't, subsection 2 doesn't restrict to the persons who are abroad.
Right, I agree.
So a person who is bedridden for 3 months or 4 months.
But in a case country, I agree with your
would also
observation.
be-
Yeah.
in my prima facie would also be entitled to relief under subsection 2.
And of course, for a country as vast as ours.
If somebody is in commanding situation for say
Yes,
for 4 months, 5 months,
absolutely right. Well, absolutely right. You could have a situation like that where family members don't know. One of the situations in this court is of a lady who lost her spouse. Now she lost her spouse, so her money she knew. But by the time she located, the spouses, where the spouse had kept the money, it was too late. And she's also been excluded from this. So your Lordship may reflect on this on individual cases, but another way of looking at it is, given the vastness of our country and the circumstances, you may have to have a more broader approach on the part of RBI, not on the part of the court. On the part of RBI, you have to have a general circular for circumstances like this. You can't have a hard stop over here, 30th December, we have an ordinance, 31st December, goodbye to everybody. So anyway, that's the background. Now, just to complete this compilation, you may just note, you needn't turn to the pages. Page 62 is my writ petition in this court. The prayer at that point of time was to strike down these onerous conditions in the RBI circular, which is at page 71. Then, of course, 71. Then, of course, your Lordship knows that mine was disposed of. I was allowed to make an intervention. Intervention application, which basically is only to set out facts, is also mentioned over here. Now, just have a look, Your Lordship. We just go same compilation, page 84. So, I'm sorry. May I just complete that? 1 or 2 dates are left in the list of dates. Page 7, please. Applicant returned to India on 3rd February 2017.
Page 7 of my list of dates. Applicant returned to India. 8th February 17, the applicant approached Reserve Bank of India, New Delhi office with the demonetized bank notes, a total of 1,62,000 along with the required documents. RBI refused to accept the old notes. The applicant addressed a letter to RBI requesting it to accept the old notes of amount of 1,62,000 in his possession, which were held in savings for the purpose of the knee operation. Notably, the letter bears an acknowledgement by the RBI. RBI orally, that's the officer, informed the applicant that only those persons who are out of India from 10th of December to 30th December 16 and have declared their currency to the customs authorities at the airport can deposit the same with the RBI. In the applicant's case, he was not carrying the old notes upon arrival, as the notes were lying in his house in his absence. The applicant's case was thus not covered by the circular. Then the 27th February is the act which comes into force, replacing the ordinance. Please go overleaf, page 8. 3rd March 2017, agreed by the refusal of RBI to accept the specified notes, the applicant filed writ petition.
Then on 6th March 2017 is the order of this court, which I have already placed before this court. 21st March 2017, the court issued notice on the applicant's writ petition. We have set out the prayer. Then on 7th April 2017, the central government filed a short affidavit in one of the tag matters stating that there is no legal duty on the part of government to extend the grace period and declined to exercise the power conferred under section 412 of the ordinance. On 30th August 2017, Press Information Bureau published a note. This, your lordship will find, is at page 64 and 65 of the compilation. From the reports, data published by RBI, currency in rupees 1,000 and 5,000 denomination in circulation was at rupees 15.44 lakh crore. Now see the next part. Taking into consideration the value of SBNs now reported to have been counted, approximately 98.96% of the SBNs in value terms have come back to RBI after demonetization. In other words, only an estimated 16,000 crores worth of SBNs have not come back to the RBI so far. Now see the importance of this point. By 30th August 2017, they had already received back 98.96% of the notes. So why have this hostile discrimination against people like me, who genuinely had gone abroad, genuine money, and you are just in this area of 0.04%, 0.04% genuine people, and you are saying, no, we won't accept your notes. Sorry, it should be 1.04, 1.98 it is, 1.04. Then 3rd November 2017, this order also I have already mentioned to the court. Top of page 10, we've given you that news report also. During the hearing, the learned Attorney General only submitted that no action will be taken against the petitioners who are before the court for the amount of specified notes held by them and disclosed in their respective petitions. The Attorney General's submission is noted in the news report at pages 84 to 87 of the compilation. Writ petition was declared to be infructuous. That is the cooperative banks, etc. We've got a news report with regard to that. Then we filed an IA, and then it comes to be tagged, etc. Notice for interventions, etc. Now, just returning back to compilation. So, Manoj, now I'm done with the list of dates. Sorry.
In a genuine case, but if a case is not genuine, what happens? For example, incidentally, you may have gone abroad and you came, and some people will to take advantage of this situation, may park their black money with you and.
But I'm
There's a
so
limit on-
I'm not in a case
There's a
which
limit.
Maybe.
that's a concern your lordship will be alive to. But that doesn't mean I just answer the moment.
To the Reserve Bank may, if satisfied, maybe they must hold an inquiry perhaps. Subsection 2 of section.
The lordships have also, now we have the advantage of a 9-judge bench and a 5-judge bench, constitution bench judgment in Puttaswamy, which says there is a presumption of integrity on the part of the average citizen. Everybody is not some money launderer. That's the logic which this court has used. You can't think and label everyone as a money launderer, and therefore we are going to completely disable all your bank accounts unless you get it linked to Aadhaar or whatever. It's struck down by this court. So there's a presumption that people are genuine, are honest. In my case, there's no doubt in my mind that I am genuine and honest. I've given you the circumstances. Nobody says otherwise. So where is the question of my property being deprived of my hard-earned money and my property?
But under the proviso, I think there is a cap.
8.96 amount has returned.
Has come back.
So there can be no real, apprehension about a lot of money being passed.
Absolutely.
It's only 1.04%.
The foundation. To that question. So I am first of all in agreement with. Yeah.
Attorney,
Lordship.
what do you think? Because, prima facie, we find that subsection 2 of subsection 4.1, subsection 2 is independent of 4.1. And the notification which is issued is under only one, subsection 1 of section 4.
Both.
The duty cast upon the RBI to consider independent, to consider genuine cases independent.
That's right.
And that is independent of 4.1 and independent of the notification.
Let me put it even outside all these
So
provisions.
therefore, some such genuine cases are concerned.
That's right. I close my eyes to all these provisions and say there is an element of fairness. There is something which is missing in the whole scheme of the Act. For the RBI, that's why subsection 2 talks about the RBI to consider. So I'm trying to look into it and I'll come back and say whatever need to be said. I'm trying to collect the entire picture.
Such genuine grievances are resolved by taking recourse to subsection 2 and subsection 3. There might be a hard case where a person must be in a commanding situation
That
for
whatever
6 months.
you're also saying something. Whatever examination the RBI will undertake in a given case will certainly should be on a fair basis.
On a factual basis.
Correct. And also take into consideration whether it will have the tainted aspect of it.
No, they
So how do they consider that?
Language itself
source
says
of funds.
making such verification as it may consider.
That takes into it. That's right.
It's broad enough.
That's right.
Cover it.
Anyway, on some individual case, I'm trying to look
And
into it.
Mr. Attorney, 98.odd% you have already come back, some small thing.
I have collected some information. I'm trying to find out how to put it in a proper framework, and I'm sure that will be.
So attorney, suppose if some person
Your Lordship, please.
is in a comatic situation for 6 months, and this period comes during that period, his children don't know where his money is. He might have kept in a locker or and if he gets
Any number of circumstances.
if
I
he
know.
is satisfied that it was beyond his control to apply within particular period, so in such cases you must provide for some remedy. And prima facie subsection 2 and subsection 3 takes care of that situation.
That's true.
It,
That's the intent.
yeah,
That's the intent.
it bestows the discretion upon the RBI and also a duty that to find out whether the results given are genuine or not.
Yes.
That's why I said I'm trying to examine some of the
Yes,
cases. I'll try.
So then at least Mr. Shyam Diwan
In fact, I thought
and the learned friend he's fighting for 30,000 from last so many days. Their grievance would be taken care of.
Attorney, actually, that 30,000 we thought we'll ourselves take care. Then we thought Shyam Diwan will ask for his share. It was beyond our salary.
it's not 1,62,000.
Oh,
So maybe so therefore, if we can just think loudly about this, at least these independent cases could be taken care of.
Yes.
Let me come back.
You could always verify about the source of funds.
Yeah, as I said, I collected some information, but I want to look at it a little more closely so that if there are some doubtful cases, can we weed them out and see how it can be.
So if he is not in a position to satisfy that his claim is genuine,
Yes.
it can be outrightly rejected. If it can be found out from the account that it was withdrawn immediately before he left India.
What I was trying to look at some of the instances, the bona fides of people who have tendered, the way they have tendered, things like that, all that will be taken into account. Therefore, I think I need a little closer attention and I have to come back.
Thank you.
No, sorry.
We are saying something in your favor, Mr.
My lord, it is only 2 pages.
Let Mr. Diwan come here. We will hear you.
2, my lord. 77219 of 2017, my lord.
We'll hear you fully.
It is not yet completed.
Yes.
In a lighter vein, I think you have been like Lord Ganesha. So every morning we come first see you and then go to the. Going out, we see you and then go out.
He blesses the court.
And he's also sitting in the middle.
So in every temple, first you will have to go to the Ganesha and then go to the others.
No,
it's necessary for me to place it because it's on the earlier demonetization case. So it will provide guidance. It's at 101 of that compilation, volume 1. So please just go to, for 1996, volume 9 SEC, page 650. Now I'll just state the points. There are 2 or 3 learnings, at least for us, from this particular petition, this judgment. The first is, according to me, this puts beyond the pale, because it's our constitution bench, so it's authoritative pronouncement, that when you demonetize and rob currency notes of its value, it is an impact on property rights. I mean, it may seem obvious, but now we have a constitution bench which says so. So at least that first hurdle as to whether currency notes were property rights or not is fully and affirmatively answered under 300A, because there was a contest at that time. That's one. Secondly, the manner in which the court proceeded was that it decided on the general principles first, and then it went individual cases with regard to certain cooperative foundations, etc., which came up. That was the broad scheme in which they proceeded and followed. So if your lordship has page 101, I'll just take you straight away to page 104. So this is a constitution bench judgment. I'll read the first paragraph initially. The constitutional validity of the high denomination banknotes Demonetization Act 1978 and the legality of certain orders passed thereunder are under challenge. Petitions under 32 of the Constitution. The Act replaced an ordinance bearing a similar title, which was promulgated by the President and has come into force on 16 January 78. To appreciate the contentions raised on behalf of the petitioners, it will be necessary at this stage to refer not only to the provisions of the Demonetization Act, but also the RBI Act, which empowers the RBI to issue banknotes and imposes an obligation upon it to exchange those notes. Then there's a reference to section 22, section 24, 26. Then please see paragraph 5 on page 105 of the compilation. Coming now to the Demonetization Act, we find that the high denomination banknote has been defined in section 2D to mean a banknote of the denomination of 1,000 rupees, 5,000 rupees or 10,000 rupees issued by the Reserve Bank. Section 3 declares that on expiry of 16/178, all the high denomination banknotes shall, notwithstanding anything contained in section 26 of the RBI Act 1934, cease to be legal tender in payment or on account at any place. Section 4, which prohibits transfer and receipt of high denomination banknotes, reads as follows. And then section 4 is set out. Please go to the discussion at paragraph 6, page 107. In assailing the Demonetization Act, it was contended on behalf of the petitioners that it violated the fundamental rights guaranteed under 19(1)(f) and 31 of the Constitution since repeal, which were available to them at the material time. In elaborating upon this contention, it was submitted that section 26 of the RBI Act casts an obligation on the bank to make payment of high denomination banknotes wherever tendered, and the central government guaranteed such payment. But on promulgation of the impugned act, those notes cease to be legal tender, notwithstanding the above provision of the RBI Act in view of section 3 thereof, and resultantly, the bank and for that matter, the central government stood discharged of their obligations. In other words, according to the petitioners, the impugned act extinguished the debts due owing from the bank to the holders of high denomination banknotes. The petitioners contended that such extinguishment of debts amounted to a compulsory acquisition of property within the meaning of Article 31(2) of the Constitution, and since the acquisition was not made for a public purpose, nor adequate and appropriate provisions were incorporated in the impugned act for payment of compensation in respect of the impugned act was violative of the above article. Besides, the petitioners contend that they had a right to acquire and hold the high denomination banknotes and to carry on any trade or business by using the same in the course thereof, and Demonetization Act, insofar as it provided for non-payment of exchange value of high denomination banknotes, except in the cases under section 7 and 8 thereof, it imposes an unreasonable restriction on the fundamental right under 19(1)(f) and (g) of the Constitution. Since it cannot be disputed that the direct effect of the 1978 ordinance is wiping out of a public debt owing to the holder of high denomination banknotes from the state, the other contention of the petitioners that their property was compulsorily acquired has got to be accepted in view of the Constitution bench judgment in Madan Mohan Pathak, wherein it has been held that property within the meaning of Article 19(1)(f) and Clause 2 of Article 31 comprises every form of property, tangible or intangible, including debts
and chose in action, and the extinguishment of a public debt due and owing to the state amounts to compulsory acquisition of such debt. The next question necessarily falls for consideration is whether there is a public purpose, etc. And then they get into the point, then they finally find that there is a public purpose, and then your lordship will just note from para 11 onwards, or after para 11, the writ petitions are, there are two writ petitions which are individually taken up and considered by the court. I'm just explaining the scheme. The individual facts, etc. are not relevant. So this is really for the purpose of completeness, to inform your lordships that there is a constitution bench judgment. Sorry.
You may just see paragraph 11 at page 109, and then I'm done with this volume. Part of this Constitution bench judgment. Now that we have found that the Demonetization Act to be a valid piece of legislation, we may proceed to consider whether the orders passed by the respondent in exercise of powers thereunder, refusing to exchange the high denomination banknotes of the respective petitioners of the writ petitions, are justified.
So this paragraph 11 is binding on us.
It is. So the Demonetization Act, that act was found to be valid, no problem. And thereafter they went into individual grievances. That's the broad scheme over there. It's your lordship will consider, will apply this case also. I don't think anybody is saying that there's no public purpose, as in the sense that that's not my case.
This is binding on us.
Yes. Now please have a look at the second volume, volume 2, which was titled that compilation, yes, documents on behalf of the applicant. There's just 2 or 3 things I want to point here, and then I'm done. Now, I'll just state the point. One of the points which was mentioned yesterday by Mr. Chidambaram was that there is perhaps a necessity for your lordships to lay down under 26(2) and other parts of the RBI Act certain guardrails. And the guardrails are necessary to know as to what are the elements or what is the extent of discretion available, how is that particular power to be exercised, etc. Now, in that context, I just want your lordships to recognize 2 or 3 pages over here. So please go to page 32. Page 32 at 56. I'm just going to read one statistic here.
Page numbers are at the foot, I think. So this is using fast frequency household survey data to estimate the impact of demonetization on employment. And please just go to the conclusion at page 56, which is print page 183 of the article. The employment and unemployment estimates created from earlier indicate that the labor participation rate fell by about 3% after demonetization. Employment during the busy October to December 2016 quarter was 0.5 million lower than the preceding quarter of July to September 2016. And the expected spike in employment during the quarter was missing. Employment during the 2 months following demonetization was about 12 million lower. So this is 1.2 crores lower than it was during the 2 months preceding demonetization. And after a 4-month period, when the entire sample is surveyed, the impact of demonetization reduces to a loss of about 3 million jobs, which is 30 lakh jobs. So you see, decisions, of course, there is government policy, etc. They are fully entitled to make policy decisions. Many policy decisions are good, beneficial. Many sometimes it's an element of experimentation. It may work partially, it may not. I'm not faulting anybody on that. The point which was made yesterday and which I'll emphasize in my turn when I come to 26.2, it's very important for this court to lay down the parameters and the guardrails. That is necessary because look at the impact, Manoj. We're talking about 1.2 crore jobs which are lost in the near term. It was transient. The impact was transient. And then it went down to 30 lakhs after job loss. But 30 lakh job loss, we're talking about life and livelihood. If there are sufficient parameters, of course, then it may not be necessary. But if you feel that there's a necessity to lay down appropriate parameters for the exercise under 26.2, then please consider it because the impact is extraordinary. And the impact runs, it really impacts families, etc. in a very, very, in a manner which is palpable. Now, please go straight away to page, so your Lordship may just see the very next page, page 57 and 58. Same, in the same vein, this is a news report of January 17, 2017. So the first statistic is on employment. The other is this report and study carried out by the All India Manufacturers Association. And please see the third paragraph. AIMO said that that those in the age group 40 to 45 are the worst hit, and 40% job losses due to the note ban based on data till December 31st. It also records that 32% of the people in the age group 22 to 30 have lost their jobs. The report says that till December 31st, some 60% job loss were reported in the sector, along with 47% dip in revenue on part of the small scale traders, shops and micro industries, medium scale industries, etc. So this is not a critique of the policy at all, not at all. This is only to come back to the court and indicate that the exercise of such powers, if left untrammeled and without any guidance from the court, can have huge human impacts which affect life and livelihood. So I am done with this. The only other page here which I want to point out, you have already seen. Sorry.
Ramjivan, what guidelines you have suggested?
Yes, so I am going to suggest.
Suggested any guidelines?
Yes, so I'm
put it in a sheet of paper and.
Yes, so I'll just answer it in one line first. In addition to what Mr. Chidambaram has covered the ground, my respectful submission is going to be when you see the reports and hear them. At a minimum, when you are taking away 86.4% of the currency in terms of value, at a minimum, and this is based on your Lordship's jurisprudence, there has to be a study. There can't be some general study on black money, trafficking, counterfeiting, fake notes. That there are dozens of studies. They've given some 7 volumes of study after study. There's not one study on the benefit or not the benefit of demonetization as a solution to all these problems. Some study when you are going for 86.4%. I mean, how does anyone apply his or her mind? Some base. So I am not on the point.
Made in public domain.
There are 2 elements here. On disclosure, that's an important principle which Mr. Chidambaram has projected. Disclosure of the minutes, the notice, the advice, the agenda notes, etc. That's one element. And then whatever inference they seem a little coy at this point at least from revealing it to the court, but I am not on that. It's not even their case that there was some type of meaningful study on what the impacts will be and what the benefits could be in terms of these particular benefits. So some general study that, there's a lot of problems because of black money and there's a huge problem of terrorism and trafficking and etc. is neither here nor there. There has to be, that's our understanding. In the context, because the question is, are there any guidelines which we are suggesting on 26.2? My specific answer is There has to be some, it may be confidential, it may be meaningful, it may be 6 months earlier. I'm not saying it has to be contemporary. There's an element obviously of secrecy, etc., which has to come for a policy decision of this sort. But surely there ought to be, I can't say has to be, ought to be a study is the short answer which I'm giving your lordships in terms of the guidelines. I'll deal with that very briefly. Now only 2 pages are left.
One thing.
Yeah.
If a specific study with regard to demonetization was undertaken, say 6 months earlier or 1 year earlier, and it would have come in public domain, then what would have been the result?
No, I think, let me put it this way. That has to, I think the question is a very important one. Question is, the language used is recommendation. Your lordship requires that, 2060. Now, when we are talking about, according to us, it has to be an informed recommendation. And that's the basis. We are talking about Central Board of the Reserve Bank of India. And if these people don't apply their mind, it will be at considerable peril to all of us. So there is a presumption that this is the highest degree of scrutiny and application of mind, which is going on. Application of mind to what? That's the question which your lordship is correctly putting to me. There may, and I concede and I accept, that there could be possibilities that if some long-wide study with some great this thing takes place, there may be some element of secrecy which is lost. That's a valid consideration which you'll have to keep in mind. But was there any study which had recommended demonetization on this scale, which would address those particular objects which they seek to achieve? At least that is the minimum. And was that placed before the board which took a decision? So study one, but I appreciate the perils of what the court has pointed out. That look, where there's an element of secrecy, what sort of study? I mean, are we going to go to every? No, I'm not suggesting that at all. So was there anything at all? I think some minimal study on impacts would be there. I don't think the central government the central government at the highest may have some.
We'll have to only take into consideration as to whether both the RBI as well as the government.
Yeah.
Why the RBI while recommending and the government while taking a decision.
That's some material.
Taken into consideration relevant factors and relevant material or not.
Yes,
or whether they have taken into consideration the irrelevant factors and irrelevant.
No, I think your lordship has put it very succinctly. I agree with that. The question is whether relevant material, when these impacts are there, now your lordship knows the impacts over here.
In this context,
Yeah.
the RBI informed the central government that 86.64% of the currency would be withdrawn from the people of India. Was this fact informed to the central government or not?
No, they are quite
Because
coy.
this is the enormity of the entire exercise.
No, they are quite coy and maybe with justification.
You are now arguing it is for them to satisfy.
Yeah, correct. I am sure they may. But now I've got only 2 pages left. So that one page, which is page 64. So, to answer the question which Justice Nagaratna put.
No, if this was informed, then the question is whether central government would have done this or not.
Yeah, so your lordship is right to put it to them. I have not found anything on the record, but I'll. Now, whether even it was available before the board is not known. This report which I read to your lordship is a subsequent currency report. So this page 64 of this compilation, volume 2, and now I'm done with this compilation, has that figure. It's the Press Information Bureau release where we get that.
Rate close by Mr. Chidambaram.
98.96%, correct? And the last thing which you on that in that compilation, page 66, just see what they did. Because ultimately when we argue section 4, it's going to be something like this. Government allows cooperative banks to deposit old notes with the Reserve Bank of India.
the relaxation comes in the backdrop of reports that many district cooperative banks did not have enough cash to disburse to farmers, etc. And therefore, they took appropriate and suitable action in terms of these under 412. So, I mean, they exercised the power. It's not that they did it. So, now I'm done with this. So, now may I just come to my submissions? So, the first submission I want to make is on Article 300, capital A. Let me just state the points, and then I'll take you to one decision of KT Plantation. So, number one, there can be no deprivation of property except saved by authority of law. Number two, this has, sorry.
Justice Mukherjee's judgment in that constitution bench, all these points are covered there.
Correct, I agree.
I think we need not go into other judgments.
All right,
It's
you
a
need
constitution judgment.
Yes. So there are three things which I just want to mention. Well, first of all, it is quite, I think by now, it's an old judgment I'm citing. So we need not possibly have to actually read the paragraphs, but I'll still mention the paragraphs to you. And I'll mention the points to you on 300A. So, but at least I didn't find that your lordship sitting as a panel in a constitution bench have so far held that property is a human right. So we have at least 4 decisions of this court in smaller combinations which recognize that
what has been held in the earlier case with regard to 31, Article 31.
Yeah.
With regard to property,
Right.
it only applicable to 300A.
Yes.
I agree with you. I agree with you.
We'll have to hold that is also a property.
Yes.
No, none of us have a dispute
Right.
that it's a property right in the 300A.
Right.
Not necessarily, labor on a point where
Okay, so no laboring on the point. So let's summarize it then.
Unless we disagree with that,
Right.
we are bound by 5 judges bench.
Correct. So I'll do only 2 things. So first, your lordships have seen my dilemma, which is that my property has been extinguished. You have already fought. That's my whole complaint. That's why I'm here before the court. Rendered no.
Or all of us, we prima facie find that such hard cases have to be dealt with in a separate manner.
I'm grateful. So that is point number 1. It can't be extinguished or rendered not. And the second is that the law itself must pass constitutional muster. So it's not enough authority of law has to be. So that's it. So may I just give you paragraphs? Would you like paragraphs? Should I put in a note? Then you need not note it. So KT Plantation is the constitution bench.
Don't make it too lengthy.
No, I won't. I'll just give you the paras. I won't quote the paras. So that now my 300A point is over. So that's over. 300A. So now we come to the second point. The second point is on Article 14. Now, Article 14, there are many dimensions. So I will.
Argument is based upon the proviso to the notification. Proviso to the notification is issued under 4.1i. Now, if your case is covered by 4.2 and 4.3, notification does not apply. Therefore, Article 14 is not necessary.
No, 14 is necessary for another reason. I'll just tell you. So 14 arises in several, there's many dimensions to 14. And it of course, it attacks the very point which your lordship has correctly put to me. And I have noted your prima facie view under 4.2, etc. So that I recognize. But there are a few other dimensions also, which I'll just project and then your lordship will consider. So the first point is, I'm going on the classical equality test. And the classical equality test, as we understand it, is that if you are using classification, then everyone who is similarly placed ought to be in that class. So if there's a single homogeneous class, you can't split that class in an artificial manner so as to result in discriminatory treatment.
Many classification.
Yes, you can't, exactly. Sometimes your lordships have called it mini classification. Now, which is the homogeneous class which I am talking about? I am talking about people who are outside of India during this period. I am talking about citizens who are outside of India during this particular period of whatever, 8th of November till 30th of December. We are all part of one class. Now, how can it be that someone who lands 1 week or 2 weeks earlier and is able to exchange his money, gets his money? I come in the month of February and I have no recourse at all. Please just consider, my lord, it's a classic Article 14 situation over here.
Mr.
There's a complete, sorry.
While somewhat notification would be in the nature of a subordinate legislation.
Notification.
Would be in the nature of a subordinate legislation. While that is issued, all sort of eventualities may not have been taken into consideration. You have created two classes. One is
That's what I'm saying.
one is with regard to resident. It
Right.
presume that a resident
Right.
normally goes for some time and comes back to India, and for them there is no limit.
Right.
There was no outer limit, no requirement of any certification. They could have gone up to 30th of March and without any requirement could have exchanged it. Insofar as NRIs are concerned, the requirement, NRIs normally, as we understand, are those persons who normally reside out of India.
Yes, 180 days.
And
We'll just check up.
Yes.
180,
normally in common parlance,
180.
they are citizen of India, but for all purposes they are resident abroad. And for them, such a restriction is imposed. So, if we read that subsection 2 and subsection 2 and 3 empower RBI to take a call on such a situation, and there is a power coupled with duty to consider such
I'm
cases.
obliged to that. No,
Then whether Article 14 would be applicable.
No, see, but that may be, I mean, on this side of the
That question may
basket.
not arise at all.
No, so I am not saying no to that at all. I am, see, the reason I'm projecting, first of all, I'm agreeing with the court. I'm agreeing with the court that if I get relief on,
The classification between an NRI and a resident Indian is a reasonable classification. That
depends for what purpose. See, that purpose is because of the grace period definition here, correct? 31st March or June. That's the scheme over here. So I am not quarreling with that. Let me just restate it. Maybe I didn't give myself.
Yours is one of those very few cases which would fall in the category of hard cases.
No,
Had you not been out of India for a particular number of days, then you would have been a resident Indian.
So I am looking at it differently. Sorry.
And entitled to treat it in clause A.
No, so I accept that. My point is a little different. Yes, the approach is different. First of all, Malad, I want to accept that if I receive substantial relief, I mean real relief in terms of section whatever an appropriate direction because of power coupled with duty, then this issue which I am raising may in a sense not arise in terms of determination by the court. But it's important to recognize the issue because it elevates the degree of the duty, the bounded duty of RBI or the case of the central government as the case may be. Now, what's that point? The point I am making is there's an artificial line which is being drawn on the 30th/31st of December 2016. There are people who arrived before. Just look at the situation. There are people who came back into the country before on 20th of December 2016. They had booked their, nowadays your lordship knows the only way to get an affordable ticket is to book it well in advance. So some people have plans to book it in advance. Some people have plans to have booked the ticket at the time of their leaving well in advance. It's a reasonably fair ticket. I was to come back in the month of February 2017. Now, the question I asked myself is, the first point I'm raising just on this homogeneous class is that look, how am I any different from a person who came back to India, say on the 20th of December and therefore had time, and me who relied upon or who was aware of the Prime Minister's declaration to the country, the Reserve Bank of India statement to the country, which said that people, don't worry, when you come back, you will have an option of going to the Reserve Bank of India. I am in the same class. Now, this is my point. I want to say nothing further. I am in the same class to artificially exclude me from a class of Indians who didn't arrive, even though held valid currency in India, is according to me an arbitrary classification. So this is my first point.
According to you, there is no nexus with the classification.
Now that's the second point. The second point is that the nexus is, or ought to be, that's what they've said repeatedly, black money. Second is fake notes, that means counterfeit or whatever fake in some other manner. Drug trafficking. And yes, so these are essentially the trafficking, fake currency, etc. and terrorism, your lordship, because that also terrorism. Now, what is the connection with my hard-earned money and any of these objects which they are seeking to achieve? So that's the second infirmity under the classical test under Article 40. There's no rational nexus. I'm sorry.
When rules are general rules applicable to lakhs and crores of people are made, can individual cases be
They must be.
consideration?
No, they must be. In my respectful submission, see, Manoj, this is the other way of looking at it is that the rational nexus which you have, terrorism, etc., you have to have a caliber. I'm moving into my next point actually on proportionality. That's also an aspect of Section 4, etc. You have to have a proportionate set of regulations. You can't deprive some people of their money when they have nothing to do with terrorism and they've got nothing at all to do with any of this counterfeiting, etc. And I have these genuine notes, and you can see my notes. And it's 1,62,000 of hard-earned money which I had taken out, which I had kept at home. It's not an uncommon circumstance at all, Manoj. And therefore, there's no nexus to the object which you're seeking to achieve. And you cannot you can't have a situation that because this is in some larger public interest, my fundamental right or my constitutional right will suffer. You have to have a calibrated response either through appropriate notifications or through appropriate rules and regulations or through an appropriate scheme by which a person like me cannot be disadvantaged. Anyway, that's my submission. That's my submission with regard to it. Then there's an element of manifest arbitrariness. Now, why am I using this expression manifest arbitrariness? We are emboldened because no less than the Prime Minister of India gave an assurance to the people of India. Now, once the Prime Minister of India says you will have RBI counters to go to, and the Reserve Bank of India and the press releases which are contemporaneous echo the same sentiment, then the question I ask myself, isn't it manifestly arbitrary to introduce an ordinance on the 30th of December which has a guillotine on the 31st of December? 1 day given. How can anyone change his or her affairs? So therefore, the measure and the baseline for what is reasonable ought to be, we have the advantage of a solemn assurance and a statement made by the Prime Minister, no less. In a situation like that, that is surely the yardstick of reasonableness. If that is the yardstick of reasonableness of whatever people expect, etc., you can't suddenly introduce an ordinance on the 30th of December saying that I'm giving you no effective window to change your money at all. And there's a hard stop which comes in on the 31st of December, and that is that. So this is my other element with regard to manifest arbitrariness, founded on the representations which were made to the country at large. And finally, I've already mentioned the doctrine of proportionality. Mr. Chidambaram has explained that at length in the context.
Relied on my learned brother judgment.
Yes, so that's a useful. So, Manoj, I will state now. Let me just state there are at least 3 decisions of our court which I'm just indicating, and I'll tell you what they say as well, and then we'll, if necessary, go into the paragraphs. So now, as far as proportionality is concerned, it arose in the Puttaswamy 5-judge bench judgment. I'm not going to the judgment. I'm just explaining it because I'm going to give you a note with the relevant paragraphs. So one of the requirements was one of the challenges in Puttaswamy before the 5 learned judges was the mandatory linking of Aadhaar to bank accounts. And this was brought about by an amendment to the rules which deal with money laundering. So the argument on behalf of the union government was that, look, this is money laundering, this is anti-terrorism, this is this, this is that, and therefore this is a matter of financial policy, etc. Please allow and sustain this linking. What this court said is that you cannot have, that's the expression which your lordships have also used.
Yesterday, Mr. Chidambaram read those paragraphs.
Yes, those paragraphs. So we have now 2. So he read to a couple of those paragraphs, which clearly indicate that just having a ritualistic incantation, that is the paragraph which they read, is not sufficient. And if this is hard-earned money of individuals, so what was the principle? The principle applies over here. You have crores of people with bank accounts across the country. You can't disable valid earned money value in those bank accounts by saying that if this is not linked, then as far as that particular money which is lying there, there'll be a presumption that this is whatever proceeds of crime or money laundering or will fall foul. It will fall foul of the money laundering rules. And this court struck it down. and said, using the doctrine of proportionality, that there has to be something which is more calibrated and reasonable. So this is my final dimension. As far as Article 14 and proportionality is concerned, there ought to be something which allows a route out for persons such as me is concerned. Now I want another, I'll just mention another item and then I'll put it in the note. I think there's a very important aspect of dignity in this case. The very important aspect of dignity. Dignity has now been recognized by the 9-judge bench in Puttaswamy as being basic element as far as constitutional values are concerned and the right to life. Now I'm on 21 and dignity. I would respectfully submit that traveling to the United States to visit a son and a family member, son, daughter, whatever, is part of our overall understanding of dignity, of having family, of emotional bonds, of renewing those bonds, of enjoying the company, of looking after whatever grandchildren if there are, and being looked after. All of this is a very important facet of dignity. And you cannot or you ought not have a situation where I am suddenly the Prime Minister makes an announcement. I have to immediately pack my bags and rush down. Forget that issue which I mentioned about the statement and the assurance made to the people of India. No, dignity is something which I carry along with me. Your Lordship have used that expression also. I mean, in the context of privacy being a portable right. It's a traveling right. The dignity comes with me. You have your Lordships in Maneka Gandhi, etc. The right to travel abroad has been recognized. So the right to travel abroad, the right to travel and reside with my family, the right to stay abroad, all of that cannot be diminished by saying that, all right, go and travel abroad, stay abroad, but your 1,62,000 or whatever amount which is remaining over here vanishes. So this impacts established rights in terms of dignity, the right to travel abroad, and important dimension of property, not 300 days so much. But the security of property is also something which is an element of 21. When I traveled abroad, I knew that this 1,61,200 was secure in my home, whatever, under lock, cupboard, etc. And all of a sudden,
in a lighter vein,
yeah,
if a person goes out of country
yeah,
for a considerable time,
yeah,
rather than withdrawing the amount from the bank, he would deposit the amount in cash to keep it safe.
yeah. So here,
Lighter vein.
right. No, so here you will see my date. But anyway, I have a withdrawal slip, etc.
You have a withdrawal slip. So
Yeah, right.
rather than
I inquired actually.
having a threat of theft, and if one is traveling for 9 months,
Right.
ordinary course you will say whatever cash I have, I will put it in the bank so that it is safe.
Or locker.
Or locker.
That may be. So what had happened here, I inquired. Fortunately, he didn't have to go through the knee surgery. He had collected certain money, etc. for a knee surgery, but then the treatment outside the surgical thing worked for him. So he had to undergo certain other surgery. We were not on that. So that was the original rationale for having withdrawn the amount and kept it in safe custody. So this is my point.
But at
Now,
any rate, they relaxed the whole thing insofar as cooperative banks are concerned.
yeah, absolutely.
See, that was done in June, 6 months later, or
Yes.
6
yes.
months later, they have relaxed
Correct.
for cooperative banks.
Right.
So that all the money which they had stocked, they could exchange.
Absolutely. Exactly what I wanted to say.
If you put it to the learned attorney, I think he will
Respond to that.
respond to that.
Yes.
All right. Now I have 2 points. Sorry. Yes. So, Manoj, I have 2 points to make. For one is on that your lordships have already grasped it. I don't know whether you require me to make any further submission. I suppose the answer is obviously no. Any further comments with regard to that section 4? I think power coupled with duty, your lordships are completely alive to that.
Yes.
There are, I mean, it's a well established.
You can give in your written note whatever if you are relying on something.
Now, then I will, your lordship will just give me a moment. I mean, there's a minute left or less. Now, the final point which I wanted to make. May I just continue? I'll just wrap it up immediately after.
How long will it take? 5 minutes?
Maybe 5 to 10 minutes. I'll just, because there was a moment.
5 minutes.
I think
Complete.
rather finish it right now.
All right, fair enough. No, they can wait there, I'll be less than 5 minutes.
They will be hearing the
disturbed by
arguments.
them. You will be disturbed by them.
So now I want to just step back. Sorry.
respect of section 26(2). That's all. I'll take a minute or two on that. Now, Mr. Chidambaram has made exhaustive submissions on that. So point I made a short while ago on this 86% of the entire currency. First, the expression is recommendation. 26(2). I'm only on 26(2). Now, if it's a recommendation at this level, did they, at least the basic elements, I believe, ought to be told to this court, and one of them has been correctly pointed out, which is the quantum, 86%. Did the central board even know about this? That's one. Second element I suggested in terms of guardrails is some study, contemporary, specific to demonetization. I am not going.
That you already addressed.
I have mentioned it, and some study, some basic study, but not some general study on black money, and those are sort of cheaper by the dozen. Those you'll get any number of on some trafficking and this and that. The point I'm making is demonetization as a solution. The impact after 86%, whether that was known, and the impact, I think that's very important. Otherwise, my only additional point is the expression recommendation takes in or draws into it conceptually and information being received by the party recommending, deliberations at the highest level before making the recommendation, and thereafter some kind of a meaningful application of mind. Now, unfortunately, using that expression ritualistic, they have in a ritualistic manner on those affidavits, which Mr. Chidambaram yesterday pointed out, those 3 or 4 paragraphs, said that there was a communication from the government to them, to the central board, meeting was convened, and the whole thing and the recommendation arrived, and pursuant to that, a decision and call was taken. I don't believe the requirements of 26(2) are also fulfilled. I'm very grateful. Thank you.
Thank you very much.
Who will start at 2?
Will my lords consider the applications which are now pending?
No, I think substantially it is argued. Now we will ask the learned attorney to respond.
On the tax models, we are almost similar here also.
All right, you have said no. That we have all, now the attorney has said he will examine. Please listen to us. See, if the attorney said he will examine, that aspect, whether how to how to safeguard your interest. He will come back.
The only difference is my application is
that should be a part of your representation if the attorney agrees. No?
We had made representation as per their.
You make one more, we will allow you, nothing to worry, provided we should all that.
Well, I will seek your lordship's indulgence to start after 2 because the legal issues which Malad supports half of the submissions made by Mr. Chidambaram on 26(2), but there are many things which needs to be brought to your.
How long will you take? 15 minutes we will grant you. 15 minutes.
If I satisfy lordship 15, maybe lordship will grant me more indulgence.
No, 15 minutes, but you can support by your written submission thereafter. 15 minutes. 15 minutes.
Lordship.
All right. See, everything is covered now. What is there? Anyway, all your names will come in the judgment. Nothing to worry. SEC it will come.
Slightly different application.
No, all your names will come in SEC. Nothing to worry.
I am seeking specific directions for investigation into the act and conduct of the RBI.
All right, it take 5 minutes. 5 minutes.
Documents.
Only 5 minutes. 5 minutes.
I will take 2 minutes.
I will take 2 minutes. That is at the end, no? It's 30,000 rupees issue, no?
Yes, madam.
All right, we have understood that.
He can take only 2 minutes. I will take that. 10 minutes.
He repeats any of the submissions, then we'll stop them there.
Yes. Any repetition, we will stop.
Yes, ma'am. Yes, ma'am.
In fact, my lords, on applications, there would be only the difference in the hardships that people would project.
All right,
We are not going into the individual hardships.
See, if a provision is made as my brother suggested, all problems will be solved, including 30,000 issue, right? But you have to spend 60,000 for that.
We will be set on 30,000.
Then, Mr. Attorney, address at 2:30. Your time, you should start at 2:30.
Very
We
well.
will be finishing
Very
this side by half an hour.
Very well.
Please start at 2:30.
Very
No 15 minutes, 2 minutes. We have said this judgment is res judicata now. No. We have already said 2 minutes. Right.
There are some tax societies also which has to be taken care of. So,
factual because there are not.
We are giving you 2 minutes, no, you can state that. No, this is res judicata now. It is binding on us.
I will.